Hey everyone, welcome to today's Explainer. I am absolutely thrilled you're tuning in because, well, we've got something truly monumental to unpack today. On June 2nd, 2026, the Supreme Court handed down a judgment that literally rewrote the rules around the deprivation of liberty for care providers across the entire UK. It was instantaneous. If you work anywhere in health and social care, this is a massive paradigm shift. But hey, don't worry, we're going to break down exactly what this means, cut right through that dense legal jargon, and figure out exactly what you need to know right now.
Okay, so here's our agenda for today. 1. The 2026 Supreme Court ruling. 2. The multifactorial assessment. 3. Determining wishes and feelings. 4. Existing DoLS authorizations. And 5. Immediate steps for providers.
Section 1. The 2026 Supreme Court ruling. A new legal landscape.
So it really all comes down to one core question, doesn't it? What actually constitutes a deprivation of liberty? You know, for health and social care professionals, this isn't just some abstract philosophical debate. This question literally drives your daily operations. It dictates your safeguarding protocols and absolutely anchors your legal compliance under the Mental Capacity Act.
To truly grasp the weight of this change, let's rewind a bit and see how we got here. In 2005, we had the Mental Capacity Act. Fast forward to 2014, and the famous Cheshire West judgment gave us the acid test. For over a decade, that was the absolute gold standard, right? But then, in October 2025, the Supreme Court heard a new case brought by the Attorney General for Northern Ireland. And that brings us to June 2026, where the Supreme Court basically dropped a bombshell. They ruled that the 2014 Cheshire West judgment was incorrect. Just like that, years of previous assumptions were totally overturned.
Section 2. The multifactorial assessment, a paradigm shift.
There's such a fascinating contrast here. Under the old 2014 acid test, it was pretty black and white. If someone was under continuous supervision and control and they weren't free to leave, bam, they were deprived of their liberty. Simple, rigid. But under our new 2026 reality, this multifactorial assessment takes over. There is absolutely no longer a single determinative test. Instead, we have to look at multiple factors. The starting point? It's always the specific, unique situation of the individual sitting in front of you.
So what are these factors you got to consider? Well, you have to look at the type of restrictions. Are we talking locked doors or maybe sedating medications? You've got to look at the duration, the effects on the person, and exactly how they're being implemented. You also really have to consider the degree of objection and how close the situation is to relative normality, meaning, would these restrictions be required even if they were just sitting at home? And finally, the purpose of the arrangement. Is it purely for care and protection, or is there an element of coercion? No single one of these factors gives you a straight yes or no anymore. They all have to be weighed together. It's like a giant puzzle.
Now, weighing these factors brings us to a really crucial nuance in the new guidance. It's called constraint by illness. If a person's liberty is constrained purely by their own physical illness, condition, or impairment, say, for example, a severe physical disability prevents them from leaving, and they can't even form a desire to leave, well, the Supreme Court says this is unlikely to be considered a deprivation of liberty. There actually has to be an element of restriction being imposed against their will.
Section 3. Determining wishes and feelings. The role of consent.
The updated government guidance shifts the focus entirely. Instead of just asking, hey, are they compliant? Providers are now strongly urged to ask, how do we know what this individual actually understands and wants? It forces us, as care professionals, to look way past mere surface-level compliance and genuinely, truly explore the individual's feelings. And here is the real kicker. The 2014 ruling basically assumed that if someone lacks mental capacity under the Mental Capacity Act, they absolutely could not give valid consent to their confinement, period. But the 2026 Supreme Court stepped in and said, actually, hold on, that was wrong. A lack of objection is now legally relevant. A person can totally give valid consent if they are conscious of their environment, have a basic level of understanding of what's going on, and are capable of expressing that they accept or are just happy with the situation. Their expression of their own wishes now carries significant legal weight.
But of course, we've got to look out for the opposite, right? What does an objection actually look like in daily practice? Well, it's attempting to leave the setting. It's refusing care, or physically pushing your staff away. It's the need for physical restraint, using covert medication or giving sedating medication just to manage behavior. Let me be clear, if you see any of these signs, it points incredibly strongly towards a deprivation of liberty. That means valid consent is highly unlikely to be present and a referral needs to be made immediately.
Section 4. Existing DoLS authorizations. What happens now?
Okay, I know that's a lot, so take a deep breath. Because the definition has narrowed so much, a ton of people currently subject to DoLS authorizations simply no longer fall in scope. Under this new multifactorial assessment, they aren't actually being deprived of their liberty. Now, reviews are absolutely needed as soon as practically possible. However, and this is important, the government has explicitly stated that leaving the existing authorization in place temporarily does not mean the person is being unlawfully deprived of their liberty. Everyone recognizes there has to be a transition period here.
Section 5. Immediate steps for providers. A proportionate approach.
So, the government has actually outlined some incredibly clear, actionable steps that registered providers and supervisory bodies need to get moving on right now. Step 1. Share the ruling, or at least a really accurate summary of it, across your entire organization. Get everyone on the same page. Step 2. Upskill your workforce on this new definition, so your frontline staff truly understand how to do the multifactorial assessment. And Step 3. Update your operational policies, your protocols, your websites, and those public-facing leaflets to actually reflect this brand new legal framework.
And to help with all that upskilling, definitely mark this date on your calendar. NHS England is going to be publishing an updated DoLS e-learning module by the 30th of July 2026. This is going to be an absolutely vital, standardized resource to help get your teams trained up efficiently.
Furthermore, the Care Quality Commission, the CQC, has put out a highly reassuring statement. They totally acknowledge the uncertainty that a massive, immediate change like this causes. So they've stated they will adopt a proportionate approach in their assessments while we all wait for the official, finalized guidance from the Department of Health and Social Care. Basically, they aren't out to catch you on a technicality. They just want to see that you're adapting, you're considering cases individually, and you're continuing to provide person-centered care. So pace the panic, but definitely start making those adjustments. Amidst all the legal scrambling, the new multifactorial assessments, and the endless policy updates, I really want to leave you with one final thought. As we implement these new legal safeguards, are we truly listening to what each individual understands, wants, and feels about their care? You see, this 2026 ruling isn't just about reducing a paperwork backlog, it's a fundamental legal mandate to return to deeply person-centered care. Think about how that changes your very next shift. Thank you so much for joining me for this explainer.